unit if you're in close proximity to transit. When the required covered spaces for the dwelling are demolished to construct an accessory unit, those two spaces could be replaced in any configuration on the site. No additional setback is required for an existing garage if it's converted to an accessory unit. And then lastly, in the case of an attached accessory unit, if it doesn't exceed 50% of the existing living area, it can be a maximum of 1,200 square feet. So for example, a 1,200 square foot house would be limited to the 640 square foot maximum that's applied to all homes. But for example, if you had a 1,500 square foot house, you could go up to for 750 square feet, because that would be the 50% maximum. So the additional proposed amendments that I mentioned, the first is that, like I said, per state law, we cannot require the third parking space if you're within a half-mile of transit. And based on how much transit is provided in the city, we're pretty transit-rich in Santa Clara, we're proposing to remove that requirement altogether. So as you can see on the map, hopefully, there's only two small pockets in the city that are not within a half-mile of transit, and that's about a little over 1,000 properties. But a large number of those properties aren't within the R1 zoning districts and wouldn't therefore qualify for an accessory unit. Secondly, when the required covered parking spaces for the single-family dwelling are demolished or converted in conjunction with the construction of an accessory unit, we are proposing that the replacement parking spaces can be located on site as covered, uncovered, tandem, or individually accessible spaces. Currently, the requirement would be that you provide 2 covered parking spaces if you were for some reason going to demolish your garage or carport. So this is a change to allow covered, uncovered, tandem, or individually accessible. Thirdly, a current requirement exists that you have to have 2 covered parking spaces to qualify for an accessory dwelling unit. But since a garage conversion or demolition would have eliminated those spaces to begin with, and they could be provided in any configuration, like I mentioned, the draft ordinance proposes to eliminate the 2 covered parking space criteria. And lastly, the draft ordinance is proposing to reduce the required setbacks. So like I mentioned, currently accessory dwelling units have to meet the setback requirements of the main dwelling unit or the main dwelling. And so the proposal is to have accessory dwelling units meet the setback requirements of other accessory buildings. So that would be a 3-foot side setback and a 5-foot rear setback. We are proposing to maintain the 40% maximum rear yard coverage, so that would ensure that there's adequate rear yard space still provided. So next steps, we have had one planning commission review, and that was on March 8th of this year. We are going to be heard again at Planning Commission on April 12th. We'll be providing the community feedback we receive at tonight's hearing. And then eventually this Planning Commission will provide a recommendation, and this will be heard by the City Council sometime likely in May of this year, though that hasn't been definitively scheduled yet. So, moving on to the next topic.
So currently we don't have a formalized policy, public outreach policy, and we are aiming to define clear direction for staff, applicants, and the public regarding public outreach policy. The methods for public outreach vary based on project sites and also the location of the project and community interest. Some of the defined methods that right now we are using are on-site notices, website information that would be available for public to use and review, mailing radiuses, which is different for different projects based on size and interest, community meetings, and associated notification methods, and also public hearing and associated notification methods. We have prepared the draft outreach metrics, as you can see in this slide, and we would love to hear your comments and thoughts about this. We have been dividing projects based on size into 4 different groups: a small, standard, and large, and also significant interest projects. The small development proposal would include construction, renovation, demolition, and expansion of single-family house, duplexes, and also accessory structures that require public hearing or use permit involving alcohol. The other standard size projects would involve dwelling units with 3 to 49 units and up to 30,000 feet of commercial and or up to 50,000 square feet of offices or industrial uses. The other defined project types is large development proposal, which will involve more than 49 dwelling units or over 30,000 square feet of commercial or up to or over 50,000 square feet of industrial uses or office uses. And the significant interest projects, which is kind of a controversial proposals coming to the city, would have a high potential for significant interest at a citywide level. And we have been defining this matrix based on project types and also different public outreach policies that right now we are using. So after this presentation, we would have a chance to go over the matrix and hear your comments and thoughts about it. We are moving to the next topic, which is the single-family residential review. And
good evening. Currently, there's another topic that we're asking your feedback about, and that is single-family residential review. Just to refresh everyone's memory about what our process was, about 3 years ago, the council mandated that we take all applications that involved a 4th bedroom, even if it's on a 1-story addition on a single-family house, to the architectural committee. But prior to that, only 2 stories were sent to architectural committee by the interpretation of the architectural committee ordinance. So right now, that process has been in place. It's presented a couple of challenges for us. One is that the agendas are extremely long, and I would say in probably about 80% of the time, we don't have any public comment related to the application. So it does add a significant delay to a project for an individual homeowner. It does present problems related to the outreach and the needed requirements fulfilling that. So it's a rather cumbersome process compared to our adjoining neighbors. And then lastly, it does delay the project for a homeowner who isn't expecting this type of process, since this is very uncommon in neighboring jurisdictions. And so we do have a chart showing what some of the neighboring communities are doing that we'll get into once we break into the groups or conduct more intense discussion on these items. So right now, just to review, the current referral for architectural committee, and that is considered a discretionary permit, meaning it is subject to appeal. It is a land use decision, and so it does have the weight of a formal permit approval. It is not something that is just can be approved over the counter, and it does involve discretion. Therefore, it can be approved, it can be denied, it can be modified, and there can be conditions added to that project. So right now, the committee does look at demolitions, and that's been also a policy mandated by the city council to refer any demolition of single family to either the Landmarks Commission or the Architectural Committee for approval, and then there has to be corresponding plans for new construction. And so even if there was a vacant lot, the construction of a new single-family home, even if it's one story, does require architectural review. Again, as I mentioned, adding a fourth bedroom would require that same process, even on the ground floor, single-story homes, and all second-story additions are subject to that process. There are other things that we're looking at that we would like your feedback, and that is, are there other aspects about single-family additions that would be more appropriate for the concern that the process basically enveloped? That's the fourth bedroom. So is there something such as floor area ratio, and what that refers to is the cumulative square footage between the ground floor and the upper floor and any other sheds or structures that are on the property, and that would relate to the percentage of building to the size of the lot. And so there might be a maximum. In many communities, average of 0.45 or 45% of your lot area would be the maximum building area, but we don't have that in Santa Clara. So there's kind of a judgment call, more of what's appropriate for the neighborhood. Is there the scale and mass appropriate for what's adjoining it and in the surrounding immediate neighborhood, those kinds of things. But there is guidance in the design guidelines that the city recently adopted that talks about sticking around the 0.66 or 66% of the lot area as kind of the maximum that we would look at before we might look at it as being potentially out of scale with the neighborhood. And that's in the addition to the first floor and second floor massing. The other thing is second-story setbacks. Is it more appropriate when there's a solid wall line, or that there's not offsets on the house to where there's a privacy concern? Is the second-story square footage, if it exceeds a certain limit to the first floor, so you're building two-story walls versus ones that are stepped in, and then are there geographic areas in the city that are possibly more sensitive than others, such as the Old Quad or potentially other areas where the neighborhood's concerned about the overall look and feel of the neighborhood. And then the other thing is our appeal process right now. An appeal of the discretionary permit, whatever body it is, it has at least one step more. So in this case, the Architectural Committee has two more processes that will go through for appeals of anybody that's either aggrieved by the decision or if another party is. So it could be the applicant who appeals, it could be an outside person that appeals. And so we're looking at, should it be expedited to allow the homeowner to proceed with a project either sooner and go directly to city council, or should we have and maintain that two-step process that goes to planning commission and then city council? Again, that's a fairly burdensome process. It's also expensive. You have to pay for each appeal process, and there's a significant delay involved in each one of those things of scheduling hearings, writing staff reports, and doing the noticing, that kind of thing. So we're looking at for your impact, your feedback related to, should the appeal process be truncated? Should it be have some other type of mechanism involved? And then the types of applications that would be subject to appeal. Let's see. And this is the worksheet that we'll be using, and you can see here the staff basically approves ministerial permits. Those are ones that involve no discretion. So it could be a bathroom, it could be a water heater, it could be minor additions. We're looking at for what feedback is appropriate to continue that process. Right now, if it's not a bedroom and it's just expansion, it's on the ground floor, the staff still continues to approve those applications. Then the administrative might be a process where there's a notice that goes out. We don't currently have a zoning administrator hearing, but some communities do have that. And what that would say is, we're going to render this decision unless there's objection, and we would do the 300-foot notice or some expanded notice. And then if there is objection, we would hold an administrative hearing. The other types would be other applications that are subject to a public notice, such as an architectural committee meeting. And then again, looking at the appeal process, should it be a one-step process or two steps, as we currently have it. So we'll be asking for your feedback on that. So please think about those things when we break into the groups. Seds, did you have a question? I'm going to transition right now to the boarding house person who's going to give you an explanation about that.
Thanks, Gloria. Lee Butler again here. And next up on the topics is the high occupancy residences. And this is something that's been a question that has been discussed at length surrounding Santa Clara University, but it is also one that is gaining more attention throughout the city as we're experiencing high rents and multiple families, for example, living in a single residential unit. And so this is a rather complex issue and something that we've been trying to capture a lot of public feedback on, and something that we've been trying to work on to address some of the concerns that the community has expressed. And we had a working group with the Neighborhood University Relations Committee. There was a subcommittee that met a number of times. It included representatives from the nearby residential areas around Santa Clara University, as well as Santa Clara University staff, faculty, and students, and also some rental property owners and managers. And through those discussions, we identified a series of concerns that the community members had expressed. Massing and architecture were two of those concerns, and those are related more so to the topic that Gloria was talking about in terms of the architectural review process. And then there were behavioral issues that were of concern, and those were primarily noise, issues related to parking, and lots of vehicles at a single residence, and those vehicles spilling over into the streets and neighborhoods nearby. Trash that was resulting from the actions of the residents, whether that's things that they're discarding or the trash cans that aren't taken in. And then outdoor furniture was another concern that was expressed. And so those were some of the symptoms that we heard about as part of those groups. And we then looked at a number of the tools that we have to potentially address some of these symptoms. Code enforcement efforts and police efforts and university efforts were all cited and are continuing in terms of addressing complaints and particularly noise concerns. Those are some of the best avenues that we have right now to address some of the behavioral symptoms particularly. And we also have potential regulatory options. We have the architectural review that can address the scale and the massing. We also have the use permits as an option, and those could potentially be used to include conditions of approval or other regulations that help address some of the symptoms that the community has experienced. I would just point out that if a regulatory option is pursued, that those top three will still need to remain. Those, I think, are critical for the success of making sure that there is compliance with any conditions of approval, as well as making sure that if there are violations, that they can be addressed immediately. So if there's a noise complaint, that the police can be called and they can come out and address the issue. As we considered what regulatory changes we could pursue, there were a number of things that came to light and that we discussed amongst these groups and with the NERC itself. One of those is the enforceability of the proposed provisions and the effectiveness of those. So can we actually act upon this? And if we are acting, is it going to address the symptoms that some of the neighbors are experiencing? Second, and I would, if you could arguably say, is the most important issue, and the second bullet here is the distinction between high occupancy residences versus single-family residences. And case law has clearly stated that a group of individuals that are functioning as the equivalent of a family cannot be treated differently than a traditional family. So if you have a group of Apple engineers that are living together and they are functioning as the equivalent of a traditional family, or if you have a group of students who are living together and they are functioning as the equivalent of a traditional single family, we cannot put in rules and regulations that distinguish and discriminate against one group of individuals versus another. So if they're functioning as a single housekeeping unit, as a traditional family would, then we have to treat them as we do a traditional family. So that is, I would say, an important concept and one that does present a lot of challenges when we're looking at the land use regulation options that we have to pursue. But we did look at a variety of things that works with those the case law. One of them is looking at the physical form, the architecture and site design versus the use. That's the architectural review versus the use permit issue. And we developed a regulatory options matrix that I'll flash up here in a minute for you to see. And we proposed some potential design criteria and conditions of approval that could be considered under a use permit or under an architectural review in relation to some of these residences. And then we considered, we heard from some that the area around Santa Clara University is more impacted than other areas of the city, whereas we've heard from others that this is a citywide issue. And so that was part of the consideration when we were going through the development of our recommendations. And finally, amortization was considered, and what that is would existing uses have to come into compliance, or would they be grandfathered in? So could they continue on indefinitely without going through a permit procedure, or would they have to, after a certain period of time, come in and go through the same process as someone would have to if they were going through a new proposal? And so I won't challenge you to read this. We've got printouts on 11 by 17 printouts at the table over here. But what we essentially did with this matrix is we broke out some options, and at this time we were looking at 3 different sort of categories. And in this proposal, we kind of moved from left to right with less regulatory to more regulatory from 1 to 6, and the first 4 included architectural review options. And that tonight, those 4 are really being covered more so by the single family permit process, which is I can't see the sign, but that's accessory back in the back corner over here. The next 2 were a combination of an architectural review process as well as a use permit process. So a potential use permit that could regulate the ability to rent the residence without having owner occupancy. And then the final one was sort of a standalone because it was a different approach. So number 7 at the end of the matrix is a permit process that would be applicable at an administrative level for all rentals, and then it could be potentially revoked if there was a violation of certain criteria. And so that would mean in that procedure, in that process, all rentals would come in for a administrative permit, kind of like a business license, but not exactly, but similar in terms of an over-the-counter type nature of it. And then should violations occur, then the ability to rent that residence could be revoked such that owner occupancy would be required. So there are a range of options up there, and we looked at all of those and assessed their effectiveness. Does it address the symptoms that the community is experiencing? We also looked at enforceability. Is there an ability for our code enforcement officers to go out and act upon these rules and regulations? And we also looked at whether or not this should be citywide or location specific. And I think kind of the takeaway message from this is there is no perfect solution. There are drawbacks and challenges with all of them, but we did understand from the community that they want to pursue, at least the community that we've spoken with thus far, that they want to pursue both a code enforcement and police and Santa Clara University option in conjunction with a regulatory approach. And so the approach that we are currently considering that is up for public discussion and taking public comments tonight. We're taking public comments on all of that, so the conditions of approval are over there as well as that matrix. But we're also taking public comments on this proposal, which would allow 6 or fewer residents in R1 zoning districts by right, and more than 6 by right in single-family zoning districts if they are functioning as a single housekeeping unit. And remember, we can't distinguish between a group of individuals that are related or unrelated. And let me get to the end of this slide, and then I'll answer that. I'll address the question for you. And then alternatively, if individuals are not residing and functioning as a single housekeeping unit in the R1 districts, a use permit process would be triggered. And so there are options for us to include additional conditions of approval or additional review standards, so parking or common area or open space requirements. And we'll also need to clearly define what a housekeeping unit is for the purposes of this, which is the next slide. But I will address the question here. Okay. Sure. So our current ordinance defines a single housekeeping unit as an individual or group of persons occupying a dwelling unit that has a single kitchen. That's pretty broad. And when we look at the zoning ordinances from other locations throughout the state and even throughout the country, we have coalesced a series of things that we can potentially look at, and we're certainly open to hearing other potential options from you all, and we can run those through the legal checks that we would need to for this type of use. But right now, what we would be looking at is, one, that all of the leasees be on a single lease and that they provide a single payment. So that's one distinguishing factor. And two, that those individuals would be sharing household common space, meals, chores, as well as food and utility expenses. And so all of those things would need to be in place in order for a group of individuals to be functioning as a single housekeeping unit. Essentially, it's the equivalent of a traditional family. And if others have ideas on how that can be further parsed or defined, we're open to hearing any feedback that you may have. So, as part of a use permit, should this approach be pursued, there are a couple of things that we would want to highlight. One, use permits go to the Planning Commission for their decision. So staff is in a recommendation capacity. The use permit would go to the Planning Commission. Planning Commission would make a decision. That decision is then appealable to the City Council. So the City Council would have the ultimate decision on appeal as to whether or not a high occupancy residence could be located in an R1 district. We can place conditions of approval on those, and we've got a series of conditions of approval as options to start the conversation as a handout at the table over here. The use permit can be revoked, and so the ability to rent the residence to multiple individuals that aren't functioning as a family, as a traditional family, that right can be revoked if there's violation of the use permit criteria. Right now, we are looking at a recommendation for applicability citywide, and I know there have been diverse opinions related to that, and so we're open to hear feedback on that as well. There is an ability, just so I'm clear with everyone here, there is an ability to provide what's called an overlay that says, only this specific area has these restrictions, and so the university area, for example, has at some points advocated for a stricter set of rules and provisions in the area just surrounding the university. And so that is an option. It comes with some other challenges, but I just want to put that out there for folks. We're also looking at amortizing the existing uses. So if a residence is functioning as a high occupancy residence, then it would have some period of time, maybe 2 years, for example, to come in and get that use permit. And the reason why we're currently thinking around 2 years is because there may already be leases signed for next year, and so there may be it poses challenges to require something like this right away versus allowing some phase-in period for existing uses. And then finally, I want to be upfront with the community here about some, I'll call it criticism that we have received, and just it'll help spur the discussion here as well. And that is, there have been some concerns expressed that by allowing these high occupancy residences in R1 districts through a use permit, you're essentially providing a path that sanctions these uses in the R1 district, whereas what are called boarding houses in our current zoning ordinance are prohibited in the R1 district. And that is correct. The R1 district does prohibit boarding houses currently. What this does is this approach would provide an option for functioning as a high occupancy residence. I think right now the concern would be that, as is the case right now, residences could just move into an equivalent of a traditional residential single-family dwelling, and they could function as a single housekeeping unit. And by doing so, you would lose that ability to provide conditions of approval, to provide stricter regulations. And so, yes, this would provide an option for legalization, but it also provides an option for conditions of approval. And so that's currently where we're leaning, but we're here so that we can get feedback on all of these topics. And that does it for the summary of the 4 topics. And I mentioned at the beginning, we were talking about breaking out into groups. We've got a few more people that have arrived, and it may be beneficial to do that, but maybe just by a show of hands, if we could see what the topic areas are that everyone is interested in discussing this evening, we might be able to either stay in a single single group, or it might be better to break out into groups and facilitate smaller discussions. And again, if we do break out into groups, for the benefit of those who came a little bit late, if we do break out into groups, we will convey all of that information out to the entire group, so that if you miss something while you're at one station, you'll get the benefit of hearing what that entire discussion was. So I was going to request a show of hands, but it looks like we've got a question first. Sure. So the question is, boarding houses currently are not allowed in R1, and the boarding house ordinance, the changes as proposed, would not solve the boarding house problem that the old quad has right now. And I will be as blunt as I can about this, because that's how I like to operate. I don't believe that any regulatory approach that we pursue is going to solve the boarding house issues outright. What I believe is that there's going to need to be a combination of efforts, and at the forefront of those are going to need to be the code enforcement, the police, and the Santa Clara University partnerships. However, that said, the regulatory options can be pursued, and none of them are perfect, and all of them have challenges that are pursued. If you've got ideas about what can make a ordinance more effective, then great, let's pursue those, and I think that's one of the reasons why we're here tonight. So the thought, the suggestion was that maybe we break into two groups. And just so you know, the thought for the breakout groups was to allow folks to not have to rotate. They could spend the entire time at one issue. If someone cares only about the public outreach policy, they can spend their whole time there. Or if they care about the public outreach policy and the single family process, they can split it in half, or address your time the way that you see fit. And so that was how we were looking at breaking up this discussion. Maybe if we could just get a show of hands, are there, and as we go around on the topics, how many folks are interested in providing comments on the public outreach policy? Okay, so we've got a few folks. How about, okay, great. So we've got a number of folks. And then this is the accessory dwelling units. How many folks interested? So we've got more folks, a few more folks there. The high occupancy residences, quite a few there. And then the single family process, a few there. So given the breakup, I think that going out into separate groups might be beneficial. If any of this group feels strongly that you really want to stay together, then we can entertain that. But I do think that we'll be able to capture more public opinion if we break up into groups. And there's a question here. Go ahead, Jen. Mm-hmm. Folks weren't able to hear that the boarding houses or high occupancy residences. They're also referred to in some instances as mini dorms. And some of the concerns that you have are related to the proliferation of those in the areas surrounding the university, such that it's compromising the single-family character of that area. And you referenced one that recently came through that you felt was out of scale with the surrounding area. We do have microphones here, so I think for future comments, I'll ask that folks use the mic. But just to paraphrase again, that the Santa Clara University student enrollment is one of the concerns that you have in terms of the increasing number of students that are then filtering out into the surrounding area. Grabbing a mic, thank you. Just in case there are additional comments. Just paraphrasing that the university can consider building additional housing as one means to address the issue, and they are, so the city has approved 600 beds at the university for additional student on-campus housing. And so another question for the group before we break up? Yeah.
Maybe it's for the specific group, but I just want to know, because I don't live in that neighborhood, but I went to a university where it was like the college area was in one place and then the rest of the town was in another, and there was the areas where they bled together. So parking and all these concerns came up. And it sounds like we're targeting the boarding house definition and enforcement as the issue, but I'm wondering, I just wanted to know if we've taken a poll or anything of like what's actually bothering people, because if there was 15 kids living in a house and they owned no cars and made no noise, would you actually care? So I'm wondering if the things that are bothering people are noise and parking. And if they are, then maybe we target the solutions at those two things instead of trying to figure out how to, fit a square peg in a round hole. I think it's a lot easier to enforce some of those other things with the code enforcement stuff. I think there's some creative solutions there, but I could be wrong. I mean, maybe we just flat out don't want human beings, like more of them. So I was curious if we could just maybe do a poll or something.
So that has been, thank you for those comments, and it has been a topic of discussion with the Neighborhood University Relations Committee and the subcommittee, and the symptoms that were identified on that earlier slide, the parking noise, trash, and thank you, outdoor furniture, are some of the top ones. And so, yes, that is certainly an option, and enforcement mechanisms are key, regardless of a regulatory approach, and through a permitting process, enforcement mechanisms are key, and that could be something that we focus on rather than a regulatory or permitting approach. At this point in time, the community that we've heard from is looking for both, but we're certainly open to those topics of discussion. And
It affects the health of homeowners, residents, even students have called, and to bring that under control will restore the health and the quality of life of the neighborhoods. And I believe you have an amplification clause there that I wrote a statement to you that I'd like to see that extended 24/7, Monday through Sunday, because the constitutional rights of all of us is 24/7 to protection of our health and the freedom to enjoy our homes. So I think that's one of the big issues to restore the health of the neighborhood.
Great. So at this point, thank you for those additional comments. And yes, we did receive the comments that you had provided related to that. So at this point, we've got 4 stations. We've got the public outreach policy, the single-family residential review process, the high occupancy residences, and the accessory dwelling units. Feel free to spend as much time. I think what we're going to do, let's try and spend about, let's see if we can do this in 35 minutes. I know that's less time than we were planning for, but let's see if we can do it in about 35 minutes, and we'll kind of gauge how the conversations are going to see if additional time is needed or if we can reconvene and kind of summarize things. Just so you are aware, we will have an opportunity at the end of this, following the reporting out from each station, we'll have an opportunity for another group discussion with everyone.